You can get on stage. Stage left, stage right. We can go either way.
Already walked over.
Really? Thanks for sharing. Forget
What's in?
how bright the light is.
On this bright white paper.
You got all your stuff, Walter?
Yes, almost. Thanks for waiting.
Do you need a minute or are you good?
Yeah, assemble yourself.
Do you need a minute?
No,
Need a minute or you good?
I need something to take notes on this.
Everybody good? I'm good. Yep, you good? Ready to go? Okay. Good evening, everybody, and welcome to this evening's meeting of the Town of Carver Zoning Board of Appeals. Tonight is July 11, 2013, and we are convened this evening to continue a public hearing which was initially commenced at our last board meeting on May 23rd, 2012. Before I do that, we have one small administrative piece to handle tonight. Our agenda reflects that we might be taking a vote with regard to the approval of our last set of meeting minutes. I do want to tell the board that those meeting minutes are still in the process of being reviewed and revised. What's more, the board members, I believe, have not seen the first draft of those minutes yet either. So I'm going to recommend at this point that any vote on the approval of our last meeting minutes be tabled at this point in time. Do I hear a motion to that effect?
Also move.
Second.
Any discussion? Hearing none, all in favor?
Aye.
So we'll table the approval of the May 23rd, 2012 meeting minutes until they are in the appropriate form, and then the board will take them up at the next meeting, which I will anticipate will be in August. Let's now go to the main order of business for this evening, which is, as I said, a continuation of the public hearing which this board commenced on May 23rd, 2012, and I am, of course, referring to case number 13-958, the petitioner being Rocky Meadow Development Corporation, Barry McNeil, care of Shepard S. Johnson, Jr., Esquire. And his office is located at 628 Pleasant Street, Suite 428, New Bedford, Massachusetts. And this is with regard to property located at 0 Purchase Street, a.k.a. 12R Great Meadow Drive in Carver. The applicant is appealing the building commissioner's letter dated April 3, 2013, withdrawing the building permit, which had to do with granting, at least initially anyway, permission to install 4,160 solar panels at 12R Great Meadow Drive, map 55, lot 1-0. And that letter was issued on, or that permit was issued on March 12, 2013, and subsequently there was a cease and desist order issued as well. The property is zoned a residential agricultural district in accordance to the Town of Carver's Assessors Map 55, Lot 105, 107, 1-6A, and in accordance to the Town of Middleborough Assessors Map 55, Lot 1-0. Before we go further, let me observe for the record that this meeting is being filmed. We welcome CCAT here tonight. who is recording these proceedings in real time, and we welcome as well all of you who are viewing us at home. Before we get into a continuation of this hearing, again, I would like to introduce the members of the board up here this evening. To my far left is Fran Mello, who has many years of business experience at a management level. We appreciate her input, as always, during these meetings. To her right is James Nowen, who has been a member of this board for many years, as well as other boards in town. And he has considerable experience both in the conservation area and the zoning area. To his right is Stephen Maynard, who owns his own construction business, and his input during the course of our meetings has also been very helpful from a construction standpoint. To my immediate left is Eric Mueller, who is the principal of Southeast Septic. Perhaps some of you have seen his trucks travel through town. He's very well versed in Title V as well as septic issues, as you might imagine. To my immediate right is Town Council Greg Corbo from Copeland and Page, who is here to make sure that everything proceeds the way it should tonight. To his right is Sharon Clark, who has many, many years of title experience in registries of deeds throughout Massachusetts, as well as in the state of Rhode Island. She's excellent in terms of looking at titles and identifying issues having to do with dimensions and other matters pertinent to zoning issues. To her right is Walter Collins, who, like Mr. Maynard to my left, has as well many years of construction experience. And finally, to his right is our clerk, Deborah Carlino. I mentioned this the last time when we opened this hearing. I think this board is an excellent board. Accuse me of bias, I will admit to that, but the depth and breadth of experience that these various folks bring to this board, I think, makes it one of the strongest boards that the town of Carver has the privilege of working with at this point, and I feel lucky to be part of this group as well. My name is Stephen Gray. I am the chairman of this board, and for many years I've conducted a private practice of law here in the town of Carver. So, having dispensed with the introductions, let me briefly recap what happened at the last meeting for the benefit of all of you who are here tonight, as well as those of you who are watching at home.
Mr. Chairman?
Yes.
I wish to recuse myself from this hearing due to the deep involvement with this project that I've had over 4 different boards and the Solar Bylaw Committee. So I'd like to become a member of the audience for this.
Very well. So in view of Mr. Nowen's recusal, we now have, as voting members of this panel, Ms. Mello, who will step up from her role as alternate to a voting member, Mr. Mueller to my left, Ms. Clark to my right, and Mr. Collins to her right, as well as myself. Those will be the 5 voting members this evening. And going forward, Mr. Maynard, who came late when we opened the meeting on May 23rd, 2012, will not be a part of the voting panel, although he will be allowed to stay up here. Now let's recap where we were when we left off on May 23rd, 2012. Initially, this board heard for a considerable period of time from the petitioner and the petitioner represented by Mr. Johnson, as well as the engineer, Mr. Reum from Prime Engineering. And we thank them both for submitting to the panel's questioning and giving their best answers. They were patient with us, and I expect they will need to be patient with us again as we continue to work through the evidence that we need to take in order to arrive at an informed decision that is based on the law. We then moved forward and began to take comments from the most of the abutters, or at least a good percentage of the abutters who wish to be recognized on May 23rd. And we thank all of those folks as well who participated and decided to weigh in with their concerns and their comments. At the end of that session, which took us to about 10:15 p.m., if I recall correctly, I called it a night and promised to reconvene and pick up where we left off, because I believe that there are still a number of people who felt that they needed to be heard. Before I begin to open up this session again for public comment, I think it would be useful as well to kind of cover the ground that we went over with the petitioner and the engineer and the lawyer. Initially, this board had a conversation about whether there could be broad agreement that this project, this solar panel project, is sited in an RA, or residential agricultural district. And I believe that there was broad agreement that, yes, this is an RA zone. That was probably the easiest thing that we could agree to that night. Next, we had a wide-ranging discussion concerning whether the use to which this property was going to be put was agricultural or industrial. And it was the viewpoint of the petitioner that the solar array is more akin to an agricultural use, because the solar panels capture the sun's rays and then process it for energy, much like a plant would. Board members, including yours truly, pointed out that in the Massachusetts general laws, agriculture is defined in a number of different chapters and sections. There is no reference to solar in any of those agricultural definitions found in state law. And what's more, the common theme that seems to run through all of those definitions is a reference to organic materials, plants, animals, growing things. So I think there was an agreement to disagree with regard to whether this was industrial or an agricultural use. We then went on to have a discussion concerning whether the current Town of Carver solar bylaw was applicable to this situation. And I think there was general agreement on this particular point that it is not applicable, and the reason that it's not applicable is because the solar bylaw was passed and became effective the first week of December 2012, after the Form A and B plans were filed before the planning board, in this case by the petitioners. This, in effect, causes a zoning freeze, so that the zoning then in effect at the time of the filing of these plans with the planning board becomes the zoning that applies to this project, even though we have a later passed solar bylaw. We then had a discussion concerning whether this was a project that needed to be allowed as of right, since the solar bylaw that is now on the books is not applicable due to the zoning freeze. There was reference given to bylaw 2210 in the use regulation schedule in the bylaws. The use regulation schedule does not mention solar anywhere, and there is this 2210 provision in the bylaws which says that if it's not mentioned in the use regulation schedule, whatever that use might be, then it's not allowed. But the petitioner pointed to Massachusetts General Laws, Chapter 40A, Section 3, which says that towns' bylaws cannot prohibit or unreasonably regulate solar unless there is some concern with regard to public health, safety, and welfare. So we began to have a discussion concerning public health, safety, and welfare, and the petitioner weighed in with regard to its position with regard to this, and their position was that there is no negative impact on the public health, safety, and welfare as a result of this particular project. And they pointed most particularly to a peer review that had been prepared by Beaufort Powers LLP out of Boston. At this juncture, I think we took our break and we heard from the public who weighed in with regard to their concerns about the public health, safety, and welfare being affected by this project. So that's sort of a thumbnail sketch of the 3+ hours that we covered. I think it's a fair recitation when we were last in session on this in May. So let's pick up now where we did leave off. I want to open the floor to the public, and I want to emphasize, first of all, that we're looking to hear most particularly from the neighborhood folks and abutters, those who have not already addressed us. And I encourage them now to raise their hands, and I'd be prepared to recognize them so that they can be heard. Yes, ma'am. You can go over to the microphone to your left if that would be convenient for you. And if you could please identify yourself by name and address.
Nancy Bedore, 15 Great Meadow Drive. We have lived in the neighborhood happily for 10 years. The past 2 has brought concerning and alarming changes to our quiet residential community. My husband has existing health issues, and we have a granddaughter living with us. Having the power lines and solar power plant so close, how is this going to affect my family's health? As I began to research solar power, many health concerns have been brought to my attention, and these are the health concerns. Breathing issues. Do panels contain silicone? If they do, they can have silicone dust, and over time, it can cause lung disease. My husband is on oxygen and at home, and 90% of the time, what's that going to do to him? Heat. Is it going to raise the temperature? Again, my husband has got the health issues. In extremely hot weather, he cannot go outside, and if it raises the temperature, he is going to be a prisoner in our home. And then the long-term effects, it may cause hyperactivity in children, ADHD. And then there also is the electromagnetic hypersensitivity. You might not even know you have this. You can develop headaches, restlessness. People don't know if they have this. And green energy is great, but many green technologies are not safe for people who are chemically or electrically, I'm sorry, I'm nervous, sensitive to electric, magnetic, whatever. What about them? Pacemakers. I have a brother who has a defibrillator. He will not be able to come to my home because it will affect his defibrillator, and it could. And the 3 things that it could do is it could interfere with the function. And it could, it could stop it. And my husband, like I said, has health issues. That is one of the things that they did say that he might have to have. That means that we would have to sell our home and move because of this. And I don't know. That's all I have to say.
And you've said it quite eloquently. Thank you for your contribution.
You're welcome.
Who else would like to be heard that is an abutter or a resident of this neighborhood before we go to a wider approach? Yes.
Steve Whitfield, 14 Great Middle Drive, lot 313, probably the house most getting affected by this. The two pictures right there of what I have to look at now. Been here, moved here in 1977, so I've been here 36 years. We had nothing but trees behind the house. Now I got this big empty lot. My vandalism, there's power lines. Kids party up there. They see windows, glasses, you know what's going to happen. The rocks are going to come flying. What's going to happen to that is, that's about all I got to say.
And thank you for that. Who else? Yes, sir.
Charles Green, 13 Great Meadow Drive. I live right across the street from the proposed solar farm project. I've lived at this address for almost 40 years. And what drew my wife and I to this location was all the wooded area that surrounded our property. When we moved into the area, we were only one of two houses in the entire wooded area surrounded by forest on all sides. In fact, the name of the street that took us to our new home on Great Meadow Drive was called Forest Street, and still is. Now, the biggest selling feature that we were bought at the time was we were promised that much of the land across from our property, and in particular the land right across the street, would never be developed, in fact, could not be developed. This proposal project has already drastically altered the natural and beautiful environment that once graced this neighborhood, and that drew this area, drew us to the area for the first time. Now, I'd like to thank the zoning board for the time they spent on Saturday morning, June 15th, to complete a walkthrough through the proposed site. I was impressed with not only your presence to actually view the project firsthand, but more importantly, I was impressed with the seriousness of purpose, the professionalism, and the courteous nature demonstrated by all the board members in entertaining some of the concerns expressed by the residents who were also present and who were being most dramatically impacted by the project. However, my wife and I left the walkthrough that morning with some very mixed signals. As much as some deep concerns for our plight were expressed by many of the board members, it appeared that much of the discussion that morning seemed to be focused on what could be done to soften the negative impact of the project. Discussions about what type of fence would be installed to try to diminish the unsightly view, what color of the fence would be less offensive than the proposed white fence, what trees could be planted to cover up the view of the fence. Does the access road have to be as wide as it is, and would the road be better paved or gravel? My wife and I got the impression that it sounded like the project was a done deal, and that the zoning board had either A, already made up their collective minds as to the project going forward, or B, felt that their hands were tied in this matter. In fact, one board member replied, "You can thank Deval Patrick for this," a comment that I'm still puzzled by today. It is my hope that the zoning board will keep in mind the obvious and immense intrusiveness to our neighborhood that is being caused by this proposed solar project that you witnessed on that Saturday morning, and try to appreciate that this is something we will be forced to live with on a daily basis. We will not be able to hop in our cars as you did that morning and drive away to another neighborhood that does not have to live next to this unsightly and invasive development. It is my hope that the zoning board does not feel helpless in this matter, nor that their hands are tied by some misread or misinterpreted state laws. This is the Carver zoning board that should be representing the best interests of the Carver community. Well, we are the Carver community that is being most adversely affected by this project, and I cannot believe that you are powerless to protect our community's best interests. Other zoning boards in local communities, West Bridgewater and Middleborough, have not been intimidated by the vague statutes that have denied specifically these solar projects in residential areas to protect not only the environmental issues, but the best interests of the community residents as well. I have been present at every meeting pertaining to the solar farm project. I have listened patiently and objectively to all the expressed issues and concerns over the past year. Aside from health and safety concerns about living 30 feet away from an electromagnetic field, aside from whether or not this project is more akin to an industrial or agricultural project, to view this project from the windows and yards of our homes that are close proximity and or abut this project, it is obvious that this project is going to have a severe negative impact on this neighborhood, an impact resulting in a decrease in not only the aesthetic value of our neighborhood, but our property values as well. I would like to submit some pictures for the meeting records of the view that we once had looking out our living and dining room windows of 13 Great Meadow Drive, in contrast to the view that we now have. Although there may not be a lot of available data to prove the negative impact of property values and properties that abut solar farms, if you look at these pictures, it is obvious that a person looking to buy a home would much prefer to have a natural view of 7 acres of forested land rather than 7 acres of metal post panels surrounded by a fence that may or may not cause health risks to their children. I'll end with this thought. How is it that an environmentally green project like the solar farm required the cutting down of 7 acres of thickly forested land that drastically altered the natural habitat and ecosystem of this neighborhood? It seems to me like such an overt contradiction, abuse, and misinterpretation of the law under the guise of an environmentally friendly project. Thank you very much for your time.
Thank you, and let me just thank you for that. Let me just make a couple of remarks. I assure all of you here tonight, as well as those watching, that we have not prejudged this case or any other during the course of the time that I've been on this board, which has been a number of years now. So I hope that that comment, although it's coming just from me, causes your mind to be at rest as to that issue. This case is new to us. We had no previous involvement with this case, although, as everyone here knows, many other boards in the town of Carver did. So we're coming to this case fresh. And I also assure you that, insofar as I'm concerned, I don't feel powerless, and I never did. And I don't think any of us up here either feels powerless with regard to the fact that this project had already commenced and the horse had left the barn. If we believe, based upon the law, local bylaw, as well as state law, that the building permit revocation was appropriate, then we will so vote. If we feel that the building permit should not have been revoked, then we will so vote, based upon the evidence. Okay? Thank you for your comments, and thank you for the pictures. Who else would like to be heard? Yes, sir.
My name's Andrew St. Germain. I live at 17 Great Meadow Drive. I recently bought in Carver due to, the landscape in the area. I thought it was a great place to raise a family. I commute probably an hour, hour and a half into Boston every day. I could have chose many other communities to move to, and Carver was the place that I chose to live. My concerns right now are not only has the landscape completely changed in our neighborhood, my concern is what happens if Borrego Electric just decides to abandon the site? What happens from that perspective? What's the contingency fund look like? I heard there was maybe $30,000 set aside. That will cost hundreds of thousands of dollars, if not millions, to decommission a site that large. There's also fire hazards. Just recently in Missouri, solar panels recently installed on a high school back in May 2013, Webster Grove High School in Missouri, passed inspection and caught fire. My question is our fire department able and willing to run into a fire in the middle of a neighborhood with, hazardous solar panels, just bursting into flames, especially 4,800 panels? I mean, that's a pretty large-scale project, industrial. So I'm not sure if we have the capability to properly protect the neighborhood from such an occurrence.
Well, I'm sure that the Town of Carver Fire Department will do its utmost if this project goes through to protect neighboring homes and property, as well as the lives of the people who live there.
Yeah. Well, I think that's something that we should take a closer look at, is what is the, contingency fund set aside for if, in the event that site becomes abandoned. If not, it's something that the town would probably have to foot the bill on.
Yeah, I think your point is well taken, Andrew. Thank you.
Okay, thank you.
Who else? Yes, sir.
My name is Jim Hoffman. I live at 8 Great Meadow Drive. I've lived there with my wife for 23 years. Been involved in town activities, the Recreation Committee, Open Space Committee. I've coached Little League basketball, umpired, played men's softball, so I sat through all these hearings, and this is actually the first time I've actually gotten up and spoke with any committee.
I'm glad you did.
I am too, thanks. It's actually the second time I've actually got up and spoke. The first was a couple of weeks ago at the planning board meeting when this site had another proposal for a housing unit come in. I wanted to hear what that was about and had some questions. Like I said, it's the first time I've ever spoke about this solar project, and the main reason for that was when the site plan was being voted on by the planning board, the town planner, before the vote was taken, looked out in the audience and told us all, this plan will, and actually I can get the exact quote here. He said, without tax relief, there is no project. The selectman and town administrator have assured him there is no tax relief on this project. This is a non-starter. So we took the town planner at his word, and one of the selectmen afterwards met us in the hallway and said the same thing. With no tax relief, this project will never see day of light. And again, maybe we were naive, we listened to what they said, we kind of dropped our guard a little bit, and now here we are in this situation. One of the main points, questions that I have about protecting the public safety, health, and welfare for the neighborhood, can Borrego Solar guarantee 100% that this won't happen, which is a solar project that's on top of a target?
Why don't you bring the photo up here and then return to the microphone so everybody at home can hear you as well.
Where does this go? Wow.
But that's a picture of a solar project that was on top of a Target department store that caught fire. All the panels melted. Because one of the concerns when there is a fire, forgive me 1 second. And I'm taking, I'll give you a copy of this as well. This is from the Fire Safety and Emergency Response for Solar Power Systems, which was put together by the Fire Protection Research Foundation. When there is a fire, the main concern, the fire department is challenged because if the fire, especially if it occurs on a bright sunny day and the modules continue to generate electricity throughout the event with no means available to isolate them or depower them. So again, if you have a fire on a sunny day, you're in trouble. If you have a fire on a cloudy day, then you have a better chance. But my concern is, and I have 100% faith in the Carver Fire Department, but by the time they get down there, the smoke, the damage, with the neighbors, especially Mr. Whitfield and us that are very close by, what damage will be caused by then? And if they can't guarantee 100%, say it's a 99% chance, why should we take that 1% chance that our neighborhood gets affected? There are plenty of other land in the town where this project could go that there are no neighbors that close or no houses that close at all. And that's really been our one concern all along, is why put it in a neighborhood that close to homes? In fact, at the special town meeting, when the bylaw was voted, several large landowners came to the meeting and wanted the bylaws changed because they wanted to have more opportunity to put solar there. They wanted solar on their large property. So plenty of people want this, and this neighborhood from day one has said we don't want this project in our backyard. And one other picture, someone had mentioned the high school in St. Louis, Webster Grove High School. I'll just show this picture as well. And that's a very small project, but you can see the smoke that came from that. And again, it all depends on the response time, but where houses such as ours that are right there, it can catch pretty quick, and then we're kind of out of luck. And then I guess the main concern that I had as well, when this plan was voted on, when the planning board had mentioned, either way, they felt as though they're gonna have to fight this in court, whether it was voting on the solar company's side or on our side, which I think kind of rubbed a lot of people the wrong way. When if you think going in that you're gonna have to go to court, and then we felt as though they sided with big business instead of the neighbors who we elected them to protect us and to represent us well. And that's why we appreciate having this hearing today, to letting us speak. So, thank you.
Thank you for coming in. Thank you for taking the time this evening. And let me reiterate for everyone that this is not a political board. We don't set policy here. We try our best to interpret the law and apply the law to the facts. So I'd like to think that we're not buffeted by political winds that may or may not exist with regard to this particular project proposal or any other. Having said that, does anyone else wish to be heard at this point? Yes, sir.
Paul Johnson, 3 Laurie Lane. I get up tonight to speak to the issue of siting and whether or not it's proper for this project to be sited in a residential agricultural district. The board at their May meeting discussed statewide definitions of agriculture. I would suggest that we have a much more local definition of agriculture found in section 9.5 of the Right to Farm bylaw. And the Right to Farm bylaw defines farming. It says the words farming or agriculture or the derivatives shall include but not be limited to the following: farming in all its branches in the cultivation and tillage of the soil, none of which has to do with solar farms. B, dairying, nothing to do with solar farms. C, production, cultivation, growing, and harvesting of any agricultural, aquacultural, floricultural, viticultural, or horticultural commodities. Again, no solar mentioned. Growing or harvesting of forest products upon forest land and any other forest or lumbering operations. Again, they went quite the contrary. They actually removed forest land. Raising of livestock, including horses. Keeping of horses as a commercial enterprise, and keeping and raising of poultry, swine, cattle, ratties such as emus, ostriches, and rheas, and camelage such as llamas and camels, and other domesticated animals for food and other agricultural purposes, including bees and fur-bearing animals. Farming shall encompass activities included but not limited to the following: operation and transportation of slow-moving farm equipment over roads within the town, control of pests, including but not limited to insect, weeds, predators, and disease organisms, fertilizers, and pesticides, conducting agricultural-related educational and farm-based recreational activities, including agritourism, provided that the activities related to marketing and agricultural output or services of the farm, processing and packaging of agricultural output of the farm into operation of a farmer's market or a farm stand, including signage thereto, maintenance, repair, storage of seasonal equipment or apparatus owned or leased by the farm owner or manager used expressly for the purpose of propagation, processing, management, or the sale of agricultural products, and on-farm relocation of earth and clearing out of the ground for farming operations. None of that has anything to do with what we're talking about in this project, which is solar in a residential agricultural area. The definitions that we have in our local bylaw do not mention solar. The notification on 9.5.4 of the bylaw said it is the policy of this community to conserve, protect, and encourage the maintenance and improvement of agricultural land for the production of food and other agricultural products, and also for its natural and ecological value. That's the relevant part of it. None of that has anything to do with an industrial solar project in a residential agricultural area. I would submit that the definitions that we have in the Right to Farm bylaw and the policy set in that bylaw are contrary to the purposes that this project has, which is to bring an industrial use into a residential agricultural area, taking that land out of agriculture and putting it into an industrial commercial use. I would submit for those reasons that the right to farm bylaw ought to be considered in your deliberations on whether or not this project is properly cited or whether or not this is a reasonable regulation given the bylaws in place at the time.
Thank you. This definitional conundrum, agriculture versus industrial, and what do they mean when applied to this particular project, was the subject of considerable discussion, as I mentioned during my opening remarks this evening. And listening to Mr. Johnson's reading of the local bylaw, I find that it is generally consistent with the definition of agriculture, which is found under a number of different chapters and sections of the Massachusetts general law. So we appreciate the reading of the local bylaw, as it does seem to be overall consistent with the state law definition of agriculture. Who else would like to be heard? Yes, sir.
Robert Belbin, 26 Gate Street. I did hand this out to the members here so they know, and I'll just paraphrase some of the issues here. In Article 1 of the purpose, to protect the health, safety of its inhabitants. There are different types of inhabitants in the town of Carver that we need to look at. Not only the people that inhabit the town of Carver, but also the wild animals, the turkey, deer, hawks, birds, turtles, frogs, and many other inhabitants of the town of Carver, that this project's going to negatively affect. Under Chapter 48, Section 4, it states zoning ordinance or bylaws which divide cities and towns into districts shall be uniform within their district for each class or kind of structure or use permitted. We did that in Section 2100, where we developed residential agricultural areas. Under 2200, under the use regulations, we further state no structure shall be erected or used or land used except as set forth in 2230, use regulation schedule, or in the Section 2240, accessory buildings and uses, unless exempted by Section 2250 or by statute. Uses not expressly provided for in here are prohibited. Okay, which kind of goes along with this is what you said earlier, is that it's prohibited because it's not in that use schedule. But in that use schedule that we do have, it does have other commercial industrial purposes that are very similar, although not the same, but it has the same type of condensation of if you're going to develop or build solar, then you can have it in commercial industrial areas. This is similar, in my opinion. Okay. In Carver's case, the welfare of the town community is at stake. We are protecting our bylaws that regulate land use in districts that are harmonious with our purposes, to protect the health, safety of its inhabitants, to conserve the value of the land and buildings, to conservation of natural resources, and the prevention of blight. And most importantly here in this town, that our character of this town is based on the cranberry industry, is based on farming industry, okay, to preserve the cultural, historical, and agricultural heritage of the community. That putting in a big solar farm like this project, industrial, in a residential neighborhood, people aren't going to be driving to Carver to go see these. I think that's going to be negatively affecting the whole town in our tourists that we try to attract here. It's my opinion that the law was enacted to protect the homeowners to install solar on their home. It was never intended to be used to bypass the rights of a town to regulate the districts of where the type of a commercial industrial entity can be located. That right solely rests on the residents of Carver, where the residents have clearly stated we need to protect the residential agricultural history and heritage of our community. The issue of welfare is vitally important. The welfare of our community would be to stop this project and any other project similar in a residential agricultural district. The diminished property values to have a blighted solar facility located in a residential neighborhood would be similar to having a neighbor with a very messy yard with cars all piled up. And also under welfare, you have to look at the emotional, physical, and psychological ramifications that this will have on the neighborhood. To be looking out every day at this solar farm, how is that going to affect their physical and emotional state? I'm not a resident of that neighborhood, but I'm a resident of Carver, and I don't want to see this. I don't want to see it in my backyard, and I don't want to see it in their backyard. And we have to protect them.
Thank you for your comments.
Thank you.
Yes, ma'am. You can use this mic right here so you don't have to go all the way across.
My name's Joelle Masco, and I live at 20 Great Meadow Drive. My husband and I bought our house about 6 years ago, and we have 2 small girls, ages 4 and 1. And I am concerned about the health effects of the solar panels, and we're only 2 houses down from where the project would be. And more than that, we purchased our house because of the backyard and the beautiful landscape and the neighborhood, and you know, it's just a beautiful place. And driving to my house now, coming from you know, where the project has started, honestly, I wouldn't purchase my house at this point given what it looks like there. And if this project were to continue, definitely, I think the property values would be going down dramatically. So that's a big concern that I'd like to have addressed. Thank you.
Thank you for coming tonight. Yes, sir.
Yes, good evening. My name's Edward Todd. I live at 3 Great Meadow Drive. I moved there with my family in 2004. We moved there because we liked the area, we liked all the agricultural, the cranberry bogs that we live by. One of the points for me, I'm a merchant marine. I go away for 4 months at a time, so I leave my family by themselves. My wife and my kids are there. The neighborhood, with all the community of the neighborhood, takes care of them while I'm away. Some of the things, I don't get to come to all the meetings that for instance, the planning boards, the selectmen meetings, because I'm away. I know I came to one of the meetings where they told me that it was a matter of their opinion and that's how they were voting. Now, I vote to put those people in to take care of my best interests while I'm away. I work on a ship that's 3 football fields long. I don't expect you to come out and drive the ship that I drive. So I'm not going to try and tell you how to do your job. What I'm saying is that you guys represent us, the community, and the people that live there. So, you know, I mean, having someone tell me before I leave that don't worry, there's going to be houses put in, and then 4 months later come back and see that this is going in, it's quite a shock to me to have something like that. To me, that looks like I'm lied to. And on the day of the cease and desist, I actually talked to the landowners. And they actually told us, they said they felt sorry for us. But the town approved it, so there was nothing. Why did the town approve it if it's such a bad thing? You know, why didn't the people listen to the neighbors? We came up, we told you, this isn't a good thing where it's going. Why don't you listen to the neighbors? I mean, my daughter, she's 9 years old, she goes to Carver. I just want to give you this. Thank you. We had a community meeting, and she was playing with her friends. 2 days later, she went to school, got 41 of her classmates to sign a petition against this on her own. We didn't tell her to do anything. She came up and said, "Dad, I want to speak to the town and let them know how I feel about this." And she did. She got up in front of everyone and spoke her mind and her classmates' minds. That even, she's 9 years old. I mean, if she doesn't, she must know what's going on. I don't understand why people that we've elected don't understand what's going on. So please represent the town like you guys, I know you can. Thank you.
Thank you for your comments. Just let me say by way of rejoinder that I hope that all of you who are here tonight and watching at home, and also all of you who attended the meeting in May and were watching then at home as well, are left with the impression that we are listening intently to both sides, and we do not intend to give any voice here short shrift that wishes to be heard. By the same token, let me again repeat what I said a couple of minutes ago. This is not a political board. We don't set policy. We are all Carver residents, and that's why we qualify for our seats on this board. But we're not an elected board. We're not a political board. Our charge is to take the facts that come to us in each case that is presented and do our best to apply those facts to the applicable law, whether it be local bylaw, state law, or federal law when applicable. So having said that, and hoping that you do understand that we are listening and listening intently, let's go on to the next comment. Who else would like to be heard? Yes, ma'am. And before you get to the mic, I think I recognize you from the last meeting. Is that true? And that's fine, but is there anyone else here who would like to be heard who was not heard at the last meeting? One other person, and then...
Hi, Mary Burbine. I'm
Hi.
at 16 Great Meadow Drive, so my house is being affected immensely. My family as well. I have 2 small children at home that I'm very concerned about their safety. I have a 5-year-old and a 7-month-old. So I just want to add my concern to, what my backyard basically looks like now from when I bought it. That was a big selling point for me, was the forest behind us, which was shortly torn away. And my biggest concern, obviously, is my kids. So I just want to add that. Thank you.
And thank you for that. Appreciate it. Okay. Ma'am, I think you're next.
I'm Chris McGrothy, and I live at 11 Captain Hall. And I just had a question for you first. Have you all read the peer review and the papers that Glenn used to put together that review?
I can tell you, speaking for myself, I've probably read it 5 times.
Okay, and the papers that he used?
I
So
beg
you're
your pardon?
familiar? The papers that he used for his information?
I have gone through those, yes.
Okay. I had that information. I also forwarded it to Medtronics, the company that makes my children's DBS.
Yes.
So I have a letter for you from them stating that there is not enough information for them to say that this is going to be safe for my children and won't affect it.
Just by way of background, you are the mother of the 2 children.
That have DBSs, which are deep brain stimulators. They're medical devices that are
And they're
implanted.
implanted devices.
They are, but I also have concerns with my other neighbors and even our children that don't have medical devices. And I've read the information that Glenn used to make his peer review, and I had a lot of questions about it. So I'm going to reference a lot of the papers. I have the papers here if you need them to reference too.
Nope,
But in
we have
Glenn's paper B on exposure to static magnetic field, it even states on page 508, 3rd paragraph, that to date, no lifetime exposure studies have been conducted to evaluate cancer induction or promotion by static magnetic fields. The same paper, page 510, paragraph 3, states that the few available studies leave a number of issues unresolved concerning the possibility of risk of cancer or other outcomes from long-term exposure to static magnetic fields. This same paper, page 511, where it gives the exposure level that Glenn is using for people with implants at 0.5 MT, it goes on to state that the exposure limits to be set with regards to these non-biological effects are not, however, the duty of the ICN IRP. So if it's not their duty, why are they setting the limits, and why are you accepting this as an acceptable limit? Paper C of Glenn's, his peer review paper, the guidelines for limiting exposure to time-varying fields on page 495 states that compliances with the present guidelines may not necessarily preclude interference with medical devices. It goes on to state that interferences with pacemakers may occur at levels below the recommended reference levels. And as you know, one of our neighbors already has a pacemaker, or their family member does, and her husband may be getting one. Same paper, page 496, under Basics for Limiting Exposure, it states that these guidelines are based on short-term, immediate health effects, such as stimulation of nerves or shocks. It goes on to state, in the case of potential long-term effects of exposure, such an increased risk of cancer, ICN-IRP concludes that the available data are insufficient to provide a basis for setting exposure restrictions. It goes on to suggest that there is evidence of an association between possible cancer and exposure levels substantially lower than those recommended by the guidelines. This is the information coming from the papers that Glenn used. He picked out what the information that he wanted to share and use for their side of the view. I'm just representing our side, using his papers. The end of the same paper, page 499, the paper states, it is the view of the ICN-IRP that the results from the research on EMS field exposure and cancer are not strong enough in the absence of support from experimental research to form a scientific basis for setting exposure guidelines, meaning they do not have enough information yet from experimental research about what is a safe level of exposure from the EMS field. So are our children and our families going to be this new experimental research to determine the safe levels? Paper D, the clinical study on pacemakers. First off, my boys have DBSs, not pacemakers. They are affected differently. Even so, this paper was based on where patients walk through a controlled field for up to 20 seconds, only being exposed 3 times. This does not compare to deep brain stimulators or constant long-term exposure. Besides my letter from Electronics, I also have a letter titled Elevations of Electromagnetic Incompatibility Concerns for Deep Brain Stimulators. This paper also states that in the absence of sound research on the effects of EMI for DBS does not permit excluding it as a possible health concern. This and the lack of long-term data on DBS therapy warrants further research. Just because there's no long-term study does not make it safe. The town of Carver has a responsibility to protect its residents. Glenn's review on page 7 regarding our property value uses a report from California on homes with rooftop mounted household panels. This does not compare to a large solar array, what's going to be going on here. It also goes on to state that future study appears to be needed to confirm whether or not this is true in the case for homes abutting large ground-mounted solar arrays like ours. We all know about the Route 44 array that had theft problems, so they ended up having to light that up 24/7. And is that what we're going to have to deal with in our backyards? And how is that not going to negatively affect our house values?
Thank you for that presentation.
Thank you.
No, we'll pass that down to the clerk, so it'll be entered into the record. Thank you again.
Thank you.
All right, do we need to hear from anyone else? Yes, sir.
Excuse me. My name is Andy Carterelli. I'm at 19 Popes Point Road. I have gotten up and spoken to this issue many different times in the beginning of the Purchase Street property happening. Mr. Chairman, I know you've said you have this board is newly involved in this. We had a solar forum on this issue that members of the state, the Department of Energy and Environmental Affairs came and were nice enough to sit on a board with members of town council as well, and gave everyone heard concerns from everybody, but and answered questions. And the one issue I see here is the hitching point to your issue now. This question is the as of right issue, because this was put in before the solar bylaw was adopted. I believe the as of right issue was an incorrect suggestion by town council to the town. The as of right provision to this was never based with the weight of law. I put this to the representative from the Department of Energy and Environmental Affairs. I asked him where the as of right came from. I asked him, said, isn't it true that it comes from the state's model bylaw that they suggest people in towns use? He said, and I also asked him, does the as of right carry any weight of law? He said no. That is just a suggestion to towns it's the way they saw it or saw the best use of it. So the way I see it right now, the town, when they adopted this, went against its own zoning bylaws, allowing an industrial project in, because on the site review plan reviews, they were all checked off as industrial, and I believe the town was incorrect and did a great disservice to the people of the town and this neighborhood. And I think this should be struck down like other towns have done. The town of Plymouth just did it to a large-scale solar development that was already erected that they had to take down.
So, Mr. Corbo.
Thank you.
Thank you through you, Mr. Excuse me. Thank you through you, Mr. Chair. Yeah, I'd like to sort of clear up the legal issue and some of the confusion concerning whether and to what extent this project might be allowed as of right. Generally speaking, the town of Carver has a table of permitted uses, and the town of Carver has a bylaw that states that any use that is not specifically listed on the table of uses for a particular district is prohibited. Now, generally speaking, what that means is that for a project such as this, it needs to be listed in the table of use in the particular district in order to be allowed. The problem or the ambiguity arises by application of state law and a particular provision of Chapter 40A, Section 3, which gives sort of special zoning status for solar projects. And what that provision states is that no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems of the building or the building of structures that facilitate the collection of solar energy except where necessary to protect the public health, safety, or welfare. Now, there are other provisions of Chapter 40A that provide other types of protection like that, such as for educational uses or certain other types of uses. And what the courts have said is that a blanket prohibition of those types of uses is not consistent with state law. Now, the courts have not interpreted this provision as it applies specifically to solar projects. But drawing by analogy on the way the courts have interpreted provisions for educational uses, we've given general advice to the town that if you do not have a specific solar bylaw, there is risk that a court will say that you cannot prohibit it everywhere in town, and because you don't specifically allow it anywhere, that it could come in basically anywhere. Now, the key to that phrase is the word, there is a risk. That does not absolutely mean, in my opinion, that these projects can and must go anywhere, although that's the way the planning board interpreted that advice and ran with it. We were not consulted about this particular project before site plan review was issued by the planning board. And in fact, we're not consulted about this particular project until after the building inspector issued his original building permit. Once we were consulted, we analyzed the issue and gave a specific opinion that, that this use is not necessarily allowed as of right, but rather the zoning bylaw should be interpreted consistently with Chapter 40A, and that the project can be regulated or prohibited as long as it's necessary to promote the public health, safety, or welfare. So what the zoning board is doing tonight is assessing this particular project at this particular location to determine whether it is detrimental to the public health, safety, or welfare. To the extent that the planning board previously took a different view, while that may have saved us from going as far as we did, that's not a binding decision on this board. This board has to apply the law to the facts that are in front of it and make a fresh decision.
Thank you, Mr. Corbo. And just by way of further explanation, I can assure everyone out there, as well as those watching at home, that this board in no way, shape, manner, or form is influenced by the previous determinations of the planning board, for which I have respect, but I don't feel influenced by those decisions. We look at this case fresh, and as Mr. Corbo just indicated, we are looking at this project through the prism of what is appropriate with regard to public health, safety, and welfare, as that phrase is reproduced in Chapter 40A, Section 3 of state law. Okay? All right, I see that we're down just to a couple of hands, and I would really like to try to wrap up the public session. Not the public session, but the citizen participation section, so that we can allow the petitioner and their representatives an opportunity to rebut. Yes, sir.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. My name is Brian Schwartz. I'm a land use and zoning attorney in Westboro, Massachusetts. Our small practice, we appear before zoning boards and planning boards, such as yourselves across the state, and particularly in regards to alternative energy, wind, solar, and I've distributed a brief memorandum to you that I'd like to introduce on the record. And I commend you for taking the time to listen to the concerns of the neighbors, because they're truly the people who are going to be affected by this project, and they're the ones who've told you that this project will be an eyesore, that it will lower their property values, that there are potential health risks. But I'm here to comment on more of the legal framework as articulated by your town attorney. And I want to inform the board that from the neighbor's perspective, the town would be standing on strong legal grounds to revoke the building permit for this project and to uphold the decision of the building commissioner. The developer's appeal relies on the notion that the solar farm is an agricultural use entitled to broad exemptions under state law, Chapter 40A, Section 3, and as articulated in Section 2230 in the Table of Uses of the Carver zoning bylaw. Indeed, in the Carver zoning bylaw and the Massachusetts general laws, certain agricultural uses are allowed in all zones as of right. However, the Carver zoning bylaw defines agricultural use. In Article 6 of the Carver zoning bylaw, agricultural use is defined as the raising of animals, fruits, vegetables, berries, nuts, or other food for human consumption. Feed for animals, tobacco, flowers, sod, trees, nursery, or greenhouse products. I won't read the rest of the definition, but it's very similar to the first sentence or two. This definition in the Carver zoning bylaw is consistent with the primary legislative purpose of Chapter 40A, Section 3. Solar farms do not operate in the manner of a traditional farm. Here, the developer would cultivate energy from the sun, electrical energy, sell it to a power producer, National Grid, NSTAR, and that utility would sell, in theory, would sell that electricity to consumers at a discounted rate. Here, the proposed solar farm will contain 4,610 solar panels, have a capacity of 3.1 megawatts, and occupy approximately 7 acres of land. By design, this project may be fairly classified as having a commercial or industrial purpose.
Just for the record, it's 4,160 solar panels.
4,160.
But who's counting?
In revoking the building permit for the failure to obtain a special permit, the town and the building commissioner are on strong legal grounds. Town council persuasively argues that an industrial solar farm is not an allowed use in an RA district, now without a special permit, and that it is reasonable to prohibit this project pursuant to 40A, Section 3. On the issue of the zoning freeze, we recognize that if there was a valid zoning freeze in place, that the new bylaw wouldn't apply. So as mentioned before, we go back to the table of uses described in the zoning bylaw that talks about broad exemption for agricultural uses, and as explained earlier, we're of the position that this is not an agricultural use, this is a commercial use. And also, I would call the board's attention to the bylaw. As previously noted, which states that uses not expressly provided for herein are prohibited. It applies in this context. So we're weighing that particular bylaw against the state law that prohibits unreasonable regulation of solar. And as your town attorney mentioned, there's not a blanket allowance of solar. Chapter 48, Section 3 allows reasonable regulation of solar farms where necessary to protect public health, safety, or welfare. There's plenty of available space in the town to install a commercial scale solar farm. You can now put a large solar farm in the Green Business Park, Industrial A, Industrial B, Industrial C, and airport districts. I'm sure that the town of Carver carefully looked for the available space for future solar farms when they enacted a very good and comprehensive zoning bylaw. And now, as a result of that forethought, there's a special permit requirement for commercial scale solar farms in the town of Carver. Absent any court rulings in Massachusetts on the regulation of solar farms, towns have broad discretion in determining what constitutes the general welfare. In evaluating proposed bylaws by other towns, the Office of the Attorney General has routinely provided guidance to municipalities over the past year and allowed numerous municipalities to restrict or prohibit the location of solar farms, especially in residential neighborhoods. The Attorney General has cited strong case law, especially in the Dartmouth opinion, interpreting the general welfare to include consideration of property values, aesthetics, the rural character of the neighborhood, and the use of nearby land. Following the lead of Hopkinton, Sturbridge, and West Bridgewater, among other municipalities, the town of Carver should closely monitor the concerns of the neighbors and be very careful in not disturbing the nearby residences in installing a large-scale solar farm. Accordingly, the neighbors respectfully request that the Zoning Board of Appeals uphold the decision of the building commissioner in revoking the building permit. Thank you.
Thank you, Attorney Schwartz. And I will note for the record that although there's broad agreement that the current Carver solar bylaw does not apply to this situation, it is now listed in the, solar is now listed in the use table as an industrial use. Okay. As we are boiling up here under the lights, I expect the rubber hoses to be taken out pretty soon. Is there anyone else that would like to speak? And I see, let's just do a final count of the hands. 1, 2, 3, 4. Is there a fifth? 5. Okay. So we're going to wrap up with these 5. Is that okay? Yeah. Hopefully, we can get this wrapped up in the next 15 minutes and then move on to the rebuttal to which the petitioner is deserving. So, yes, ma'am. We did. And I'm not sure that any of the 5 that just had their hands up, you were heard, she was heard. Who else wanted to be heard? Were you heard at the last meeting? I was not heard at the last meeting. Okay. And Chris, I know you were heard at the last meeting, right? So is that 5? So after you're done, we'll take you, ma'am, and then wrap up with the final 3.
Mr. Chairman?
Yes.
We had asked some of these participants to provide more information for us, and I believe that's what they're doing.
Right. Great.
You asked us to start anew. This is what we're doing. My name is Michelle Cohen. I live at 3 Leland Way. Originally, there's a letter that I included that I read at the planning board meeting when they were deciding on this. So bear with the numbers, the years, and everything. There's also a letter included. I suffer from severe migraines, and while my daughter's not going to be 20 feet from the panels and the inverter anymore, it still is going to affect our family. My physician and a nurse practitioner in her office have seen me for this issue, and bright lights significantly affect my migraines. In the morning is where the glare is going to come off the panels substantially. And to be honest, I really don't want to start my mornings off like that, and it's going to reflect into our backyard, and our bedroom is in the back, in the back of the house. And if you ask my fiance and my daughter, you really don't want to be around me when I have a migraine because I'm a bear. The other thing is, I think I touched upon this last time, but with health risks, the planning board, Will Sinclair, was willing to try to find a health fund for the residents, and not just our neighborhood, but Great Meadow as well. And to be honest, I don't really want to be a guinea pig, and I don't want my 4-year-old to be a guinea pig.
Can I stop you there?
Yes.
Did you say health fund?
Yes, he, at the planning board meeting, and I'm not sure of the dates, so I apologize, but he recommended that maybe that we should think about setting up a health fund for the residents for future, any health problems that could be related to these solar panels going in.
Okay. Let's move on from that.
Okay.
Okay.
And that's basically where my biggest concern is. I mean, the people on Great Meadow, do you really want to put their lives at risk? And granted, there's no long-term studies, so you don't know if there's going to be any long-term risks. You don't know if there's going to be any long-term risks for my family or the residents in my neighborhood either. And for one company to come in and put the lives of so many people at risk just for one project doesn't seem like it would be very fair to us. So,
thank you.
Thank you.
I'm sorry you had to wait so long.
That's okay. I've shared my comments before, but I haven't before this board, so I apologize to those of you who've heard my comments before. But first of all, thank you for having this special meeting. We all do appreciate the opportunity to voice our concerns about this large-scale solar project. None of us here are opposed to solar energy or to any other forms of alternative energy. I think that's clear. We need it, the town needs it, the earth needs it. It's not something that we're opposed to. It's just the siting of this is we feel inappropriate. I grew up with solar panels on my house, so it's something that I am comfortable with in that venue. The town of Carver should be commended in its efforts to advance the causes of green energy. In fact, in its recently published, just January, I believe it was the planning board, but it was the town development strategy, the community development strategy is what it was called. It was published recently in January. It cites some sustainable development principles that were published by the Governor Patrick in 2007, and this community development strategy cites these development principles, these sustainable development principles, several times in this document. The current 330 panels array on Route 44 is a very thoughtful application of these principles. It is sited in a commercially zoned area. It is away from a residential area. It minimally impacts local residents. It's in sight of passing cars. This proposal of Great Meadow is very different. It's more than 12 times larger than Route 44 installation. It directly abuts residential homes, by some cases by less than 20 feet. It's in view of many residences of Middleborough, which is where I live. In the hasty progress of this construction, it's destroyed 7 acres of trees, as you've heard. These 7 acres of trees have been an integral part of that rural character that the town of Carver states explicitly that they wish to preserve. It's also eliminated the water filtration those trees provided, the wind barrier from storms, and also the natural habitats that's been mentioned before. I also proposed that in the haste to approve this project that it's effectively ignored one of the governor's sustainable principles, and that is sustainability principle number 2, and that is to advance equity. This principle states that it will to promote equitable sharing of the benefits and burdens of development, to provide technical and strategic support for inclusive community planning and decision-making, to ensure social, economic, and environmental justice, and to ensure that the interests of future generations are not compromised by today's decisions. I propose this project does not promote equitable sharing of benefits and burdens of development. Rather, it unfairly targets a single neighborhood, a neighborhood that has been identified in this community development strategy that has been published by Carver as one of Carver's most distressed neighborhoods, and that's a quote. This project has not involved inclusive community planning and decision-making to ensure social, economic, and environmental justice. Rather, the planning and decision-making has moved forward with very little regard to the concerns of the immediate community. The project will adversely affect property values in the area if it hasn't already, which is not economic justice. And the destruction of a pine forest is questionable in the benefits the solar field may provide. And is this project ensuring that the interests of future generations are not compromised by today's decisions when a neighborhood is being recreated where the adults want to leave and the children may not want to come back? There are better places for this project, places that have already been identified by your solar bylaw committees, subcommittees, locations that are appropriately zoned and do not carry with it the scar of unpopularity and questionable decision-making. Does this town really want to be the example of how to do it wrong? You all have a difficult job. To coordinate and facilitate the sustainability of all that makes up a town is a great responsibility. It is possible in the process of progress to make mistakes, but it's not too late to reverse this one. Thank you.
Thank you. All right. Who's next? I guess it's you.
James O'Brien, 4 Great Meadow Drive. Thank you for the opportunity to speak again. And thank you, Ms. Clark, because we were asked to bring back a lot of what we had put forth, and that was the goal of what we were doing today.
Good.
This has been going on, and again, I've been a member of and a part of this and a member of the Solar Bylaw Committee for about 2 years now, almost. So trying to finite the information that we're giving you is a fairly difficult process because we've been through a lot of this so many times. There's a couple things I would like to bring forth to stay within that legal part. If we look at the model bylaw that was created by the state on page 3 for solar installations, there's a section on methods of designating a location, and I'd like to read a clip from that part where it says, however, the DOR strongly discourages designating locations that require significant tree cutting because of the important water management, cooling, climate benefit trees have. The DOR encourages designating locations in industrial and commercial districts or on vacant, disturbed land. So, I mean, this is part of the model bylaw that the state is putting forth, recommending that this kind of project that's being put forth is not allowed and shouldn't be allowed. It shouldn't be encouraged in any way. I also have a letter from a Berkshire Planning Development, which is addressing the CLRPA, the Comprehensive Land Use Reform and Partnership Act. And part of what they discuss within that is on a similar text where they say, while we support inclusion of an accessory use of alternative generating facilities for the purpose of supporting the agricultural operation where it is located, we believe the inclusion of terms such as primary purpose when opening up to potential use by other farms for agricultural purposes creates a potential for some agricultural farms to become primarily energy farms. It also states that we strongly oppose the inclusion of this section in CLRPA while it seems to allow the siting of renewable energy facilities in agricultural areas. We believe that this section goes far beyond and is a major move to create farms which are primarily energy farms and have little or nothing to do with agriculture. And what they're basically saying is that they want to support protecting those agricultural lands for what they're worth as opposed to putting this in non-agricultural use on that. So I can turn these copies in if you like that, unless you have those.
That would be great.
I also, I also have these are 2 articles from New Jersey, and they're from appraisers in New Jersey who discussed how a large solar farm near residential land will certainly affect property values. And after those 2 articles, in the back of that is a letter which I'd like to read for the public from Caldwell Banker, local real estate agent. Actually, several agents signed this. And it was a letter written by them that states, as local realtors, it is our professional opinion that adding a large-scale solar photovoltaic field to a residential neighborhood will have a negative effect on property values. When an industrial project is brought into a residential neighborhood, there is no doubt that direct property values will decline. There will be no direct benefit from the solar panels to the neighborhood whatsoever. If we were putting solar panels on our home's benefit, that's going to increase your property value. When you put an industrial project right in behind our homes, it's not going to increase our property value in any way. And to say that it's not going to negatively increase our property value, I don't understand where that context would come from. I know that the mention has been made of of Dartmouth and the AG's decisions and not allowing projects in residential areas and accepting that towns are restricting that. And I think, to reiterate some of what's been said, as a community, we've been very open to this. I worked on the solar bylaw committee for 1 year, along with Mr. Nowen and a few other members, where we unanimously agreed on a map that had a restricted overlay. And part of the issue was that within that area, there were too many variables to allow it within that area. Now, at town meeting, that was removed. And in my opinion, what that does is also increase, showing that this town is very willing and acceptable to allow solar. Now, the proponents have stated that they're trying to be neighborly, but in no way is this a neighborly act where they're trying to force a project that does not suit what this town has clearly said is a viable project in some place that should be put right. We have space in this town. If they were neighborly, they would move it to where it would fit and where it would work. There's no reason that this has to be forced down our throats this way when it's clear that there's so many circumstances where it's not being allowed, and we're a community that's saying we're very open to allowing it. But let's not make it where it doesn't belong. And there's enough law and enough circumstance here to say that this should not be a project that should be put in, and has affected our property values. And in fact, there was a resident that lived at 16 Great Meadow before the owner there purchased the property, and they had produced a letter that they gave to the planning board which stated that they had the house sold and they lost that sale of the home when the people found out that the project was being put in. Now, I've spoken to the planning director several times to ask for that letter, but he doesn't seem to have it. But we do have the videos of that, and it is on the video where she actually hands him the letter of that. So, I mean, it's clear that it's going to negatively affect our property values, which is our welfare. It's our homes, it's our life. And to allow something like this for a commercial purpose that doesn't benefit any of us in any way is just downright wrong.
Okay.
And I appreciate you listening to
Any
your
other
time.
evidence that you'd like to present to the board?
No, thank you.
Okay. Just by way of clarification, under the current Carver solar bylaw, these projects are allowed by way of special permit
In residential
in
agriculture.
residential zones. Just point of clarification.
With a 200-foot buffer, which, if they were really neighborly, they would apply that. But if they apply that, this project will not be viable for them at all, which just shows that it doesn't belong there.
Thank you. All right. Yes, sir.
Thank you for hearing us again tonight. My name is Art Tobalski. I live at 3 Leland Way. As requested at the last meeting, I've got a number of pieces of evidence to support what we've been talking about. One of the issues that was raised last time by one of the members of the board was the issue of glare. I've got 3 different reports, one that talks about a 10-degree temperature increase in a home that subject to the glare from the panels coming in the windows. And then 2 different locations where there's been panels installed that were supposed to be no glare panels. Now, one including the one up at Manchester Airport that has gotten so bad they've had to cover it up for the safety of the aircraft that are trying to land there. Similar to those projects, we've also been told here that there's going to be no glare here. Mr. Rayum had also provided some views showing the sun in a few select positions and what the glare is going to do to the houses. And one of the big concerns there is that the houses that we're showing scaled out to about 7 feet tall, hardly representative of what we have in the abutters of this property, where we have raised ranches and the elevation of the decks and the main floor of the homes is about 10 feet up. Property value concerns, they were mentioned. I've got a few pieces of that talk to that. One of the common themes in all of those, however, is that with the large-scale projects like this in the residential areas, it's fairly new, so there's not a lot of history of transactions. As James just mentioned, there's a couple from New Jersey that have opined on what's going to happen with these. One of the appraisers was even going so far as to say that it's not just the direct abutters that can be impacted by this, but it can be the community as a whole if it changes what the community is known for. Carver, prior to this, certainly was known for the rural character. And at this point, there's been communities around here that I've read it in the newspaper. They've held Carver up as an example of what you don't want to get into with solar. and basically the problems that we're dealing with right here and right now with this project. Similarities with wind turbines is something that was mentioned in the peer review that Mr. Berkowitz had prepared. And as was stated in there, there's not a lot of impact to the property values. That was focusing on projects local in the United States. There's other countries that have had a lot more experience with the wind turbines as a comparison. Denmark, for example, has had wind turbines a lot longer than we have here, and at this point there's a law in the country that dictates how you determine the lost property value and provide payments to those living near the turbines. Canadian studies have found similar things with projects that have been there for a while, 25 to 60% decreases. And that's something that certainly seems like it, even though it's a completely different project, can draw some comparisons here. It's something that as it's matured, claims that it's not going to impact property value have come to be found false. Now touching on the welfare concerns that have been mentioned specifically because of 40A Section 3. In 2010, Carver Open Space Plan shows the Purchase Street as a scenic road in the area. Big project like this, visible from the road, just goes back to what was mentioned by the appraisers in New Jersey, that you can change what the area is known for and impact values beyond just the direct abutters. Security lighting is one issue that on the initial application for the planning board site plan review was said is not required. However, at the tail end of the hearings there, it was mentioned that site security lighting may become necessary, and this is right around the time that up on Route 44 there was the theft issues. Community of Holliston, as an example, considered the absence of a discussion of security lighting to be enough to deny a project. Can't even determine what the welfare issues are going to be there. Maintenance is maintenance is an issue that hasn't really been touched upon here, but it's been mentioned that this is by the proponents that this is something that's not going to require any involvement from anyone to keep it going. It's just going to be there and be silent, be out of sight, and out of mind, and whatnot. However, the maintenance plan that was submitted as part of the planning board review mentioned that these panels are going to need cleaning. As a butter of the earth removal operation that's going on temporarily right now, I can tell you just how much dust gets generated there. Can't even open the windows at the nice times of the year because of the amount of dust that comes in the house. When panels are put in places where there's a lot of dust like there is now here, they need a lot of regular washing to basically to keep the panels effective. That hardly sounds like something that's not going to have anybody coming to take care of the project. Beyond that, things like the inverters, those have a finite lifespan. They're going to need to be replaced 1-2 times during the life of the project. Not something that's just going to be sitting there without anyone coming to touch it.
Can we wrap up, Mr. Tobolsky?
Yeah. So we've also got the original site plan application here, which would check this project as an industrial use. I know that was mentioned last time as being something you hadn't seen. Touching on the Mass General Law, agriculture, you can't prohibit, unreasonably regulate, or require a special permit. Religion and education, you can't prohibit, regulate, or restrict. Solar, it's just you can't prohibit or unreasonably regulate. Fits in with what's been mentioned by the AG of allowing these to be kept off of certain areas, and certainly can be done harmoniously with our bylaws in effect at the time. And just the last, beyond a couple of points of the Carver bylaws, most of which have already been mentioned here, as the U.S. Supreme Court basically has allowed about 100 years us to separate our different zones, different types of land. One of the key sections in that decision was that this type of separation of uses applies even to the right thing in the wrong place. Certainly seems like it's what the case is here. Nobody's saying that this isn't a good idea, just that it's the wrong place for it. Thank you.
Okay.
Chris McCaffrey, 71 Purchase Street. I'll keep my comments very brief.
Thank you.
These are reviews of town bylaws by the Attorney General's office. There's 7 towns here that have prohibited solar power plants from going into residential neighborhoods. Even though it's been stated that there's no case law that has been challenging Chapter 40A. Obviously, the Attorney General feels these towns that are prohibiting solar facilities from going into residential neighborhoods, that these are legal bylaws, and they approved them. And I would ask the, the zoning board to also disapprove this project and to back up the zoning enforcement officer and support town council in their decision for the cease and desist. Thank you.
Okay. We have heard extensive testimony from interested members of the public both tonight and at our previous meeting on May 23rd, 2013. Before I wrap up this part of our meeting and turn back to the petitioners for their opportunity to rebut, I would like to ask if anyone else has any evidence that they would like to submit and make part of the board file. I'm not asking for more testimony, just evidence. Okay. One more. Another one. Thank you. Thank you. Fran, just pass that down. Okay, has everyone relieved themselves of all the documentation that they have brought this evening? I say that tongue-in-cheek because we really do appreciate the concern and the involvement of all of you who are here tonight and all of you who may be watching at home who have an interest in this. Obviously, the more information we have, the better informed of a decision we can make on this case. Again, applying the facts of this case to applicable local bylaw and state law. So at this juncture of the hearing, I would like to give Mr. Shepherd, on behalf of the petitioners, an opportunity to rebut some of these concerns that have been raised by various members of the public. He's been waiting patiently, and I'm sure he has a number of things to say. Mr. Shepherd, could you approach the microphone?
Thank you, Mr. Chairman, and hello, everybody. I greatly appreciate the comments from the chair and town council. After all, this is a difficult thing for non-lawyers to understand, that your job as the Zoning Board of Appeals is to weigh the evidence that you have and determine essentially a legal determination here. And so, as much as some of the comments are certainly heartfelt and emotional, many of those, I suggest to you, are answered by the facts and documents submitted on behalf of this application. Since the last hearing, in response to a series of questions at that hearing, the applicant here has delivered a number of different documents. I'm going to ask Mr. Reum to speak briefly on a couple of these, but I'd like to just give you a quick overview of the supplemental materials that were provided for the Zoning Board of Appeals to consider.
I hope quick is the applicable word here.
Thank you.
Thank you.
As you pointed out, I have been waiting for an hour and a half. I would appreciate just a couple of minutes.
Sure.
Thank you. There's a thick package of information concerning electromagnetic information. You know, I think if you look at it, you will see that the impact from this project at the property line is less than the microwave in somebody's home or the TV in somebody's home. I'm not trying to suggest that the concerns for health should not be considered. I'm merely trying to suggest to you that they are misplaced concerns that there's a misunderstanding on the part of the people who are concerned about this project, because this project does not involve any possibility of the type of health concerns that people are concerned with. We've provided detailed documents to indicate to you that the evidence is clear, that there will be no such problems. For example, the exposures that we have here, as was requested by this board during the on-site, will be so minimal that it will not even be detectable above background in comparison to the electric fields that are already present in background. And that includes the information from the N-star lines based only on public information. Those high-tension lines are not owned by the applicant here. That's a different company, and those lines are a whole different thing. But the information we've provided for you will show there's a fact sheet, there's a background scaling information, and all kinds of other information that are actual evidence from reliable, documented sources, not just emotional comments that do not have any substantiation. We have noise data that I'll let Mr. Reum speak to. We have glare details. We have information about rain noise. We have a geotechnical report that was submitted earlier in this permitting process to demonstrate that the support systems for these solar panels do not enter the groundwater table. They're well above the table. There's no way that groundwater can be impacted. There's absolutely no way that there's going to be any kind of impact to subsurface conditions, and that's contained in the geotechnical report. There's a property valuation appraisal by a licensed Massachusetts appraiser that we have submitted to you. He found that there's essentially no impact in any of the case studies that he's looked at in the real factual world in reviewing homes that are near solar field projects, including one that's in this very neighborhood. And one of the persons who spoke tonight against the project actually told their broker, as is cited in this package, that the solar project had no impact on their decision whether to purchase or not purchase the home. And you'll find it right in the real worth appraisal. I'd also like to mention that there are several other solar projects in Carver, as you folks are probably aware. They are as close to properties. One of them is immediately adjacent to school. The project on Main Street is right next to the elementary school. But of course, there's no health and safety impact there. In fact, one of the most popular places for solar panels to be placed these days is on top of school and municipal buildings. So it's widely known that there are no health and safety impacts, and it's a great way to go green. Before turning the microphone over to Mr. Reum for Prime Engineering, I would just like to sort of briefly look at some of the comments and briefly rebut some of the comments you've heard, and then when Mr. Reum talks about a couple of these items, I will quickly close with a summation.
Thank you.
Thank you. In terms of this particular project, I think that the board is correct and the advice from town council is correct, that really what you're trying to do here is to determine whether there are any health, safety, or welfare impacts from this project. And I think that it's important for you to look at the evidence you have as much as some of the emotional pleas are pulled one's heartstrings. Frankly, we all, or many people, do not like change, and anything that moves into the neighborhood is cause for upset. And in this case, there's been a lot of comments about intrusiveness, developability, you know, animals. You know, the petitions from the kids is pretty heartstringy. But the fact of the matter is that the kids really don't know what's going on. They don't have the facts. They don't have the data that your board has. You know, the children that are suffering with deep brain stimulators, I mean, my goodness, what a terrible situation to, and I feel bad for that family. It's a terrible thing. But the fact of the matter is that the power that's running down the street and in front of the house and in the wires in the house are so much stronger than what this project will involve, that it's as we've demonstrated in complete evidence in front of you, that it's just really not relevant. You know, we have a situation here where somebody mentioned tax issues. Well, the town's going to get over $300,000 from this project without really having to provide a heck of a lot of service. Not like a residential neighborhood goes in and you weigh the kids in the school versus the cost of putting them through. You know, we have a situation where we have a peer review that was done by an outside consultant selected by the planning board. It was no choice of the applicant. The applicant had to pay for it, of course, but the applicant did not choose this outside third-party peer reviewer. It was by no means a party selected to advocate for this project. We have a situation where there's been some questions about fire hazards, which is a legitimate concern. And, you know, but the fact of the matter is that the fire department has reviewed this in every detail. They have made comments, and the proposal has been modified to meet every concern that the fire department has. They did not take the position that this was in any way a hazard, and it's really stretching to suggest that by any means that this kind of a project is going to have any emission of any kind. I think we all recognize that there's no air emission, no water emission, and no noise here. I do want to comment on one of the things that, that I think is important, which is that you are weighing the weight of the evidence before you. And in that regard, I hope that you will consider the comments of the planning board in their site plan approval process. You know, that was just one of the multiple hearings this project has gone through. I believe there's well over a dozen public hearings for this project so far. That planning board unanimously found that, quote, "the project will not adversely affect the health and safety of either the residents abutting the facility or of those living nearby." That's just the planning board's opinion based on what they heard, but I hope that you will consider that as fellow citizens who are in the position to be hearing the project as yourselves. You know, we have the peer reviewer who was independent who said this project will not adversely affect the health, safety, or property values. We've got, you know, a building permit was issued. All the things were done in this project that needed to be done. And at the last minute, the building commissioner, who has since left town, withdrew the permit. He did not cite any activity or any change in any circumstance to support that revocation. He did not indicate that there was any kind of a health and safety threat. He did not indicate why it was that he changed his position, but it is clear that because he asked for a letter from town council essentially saying, will I be sued if I changed my position, that he was just responding to political pressure, and I hope that this board will not vote on a similar basis. We have agreed that the applicable, well, I'll get to that in a moment. I'm sorry. Why don't I turn over to Mr. Reum so he can explain to you some of the detailed engineering work that was done in response to questions from this board with respect to glare, noise, and rain. I'm sorry, glare, rain noise, and noise data from the transmissions.
Thank you for that.
Thank you. For the record, my name is Richard Rayom, Prime Engineering, and I submitted to you paperwork, stamp drawing with glare, angles of incidence, and angle of refraction, engineered stamp drawing with the calculations and the diagrams. And we did it for the nearest building to the panel. And Eric is right that there is a neighboring panel that is further away from the panels that is slightly higher. But you can see from the diagram that there would be no glare at any time in anybody's homes in either direction.
I'm having a little trouble hearing you. Can you make that microphone a little bit closer to your mouth?
Closer or further?
That's better.
That's better, okay.
Can you start over?
Yes. We submitted to you a drawing, stamped engineering drawing, that shows the angles of the incident of the sunlight refracting off the panels and the angle of refraction. And it demonstrates it at all the most critical times of the year, the winter solstice, the summer, the spring, and basically starting at dawn to sunset. And in that, it demonstrates that there will never be any glare into anybody's homes. They'd have to basically stand on their roofs on a ladder in order to be able to see any light. With regards to noise, there was a question of the decibels coming from the inverters and the transformers. It's basically about 65 to 70 decibels right at the inverter and the transformer. That's comparable to the sound of somebody conversing. That's at 1 foot from the transformer. Decibel, basically sound diminishes by a factor of exponentially as you go away, so that the difference between 1 foot away and 100 feet away is less than 1,000th of that sound. And so
those inverters are how far away from the nearest
property line is about 300 feet. So basically, at the property line, it would be comparable to a quiet whisper in a library, or the rustling of leaves on grass. So they will be not discernible because of background noise, even in the dead of night, has sound to it. I also submitted documentation of the sound of rain on the panel and did the same analysis of how far the panels were away from the property line, and gave you levels of somebody was in their home, in their backyard, and right at their property line. And we didn't take any credit for the sound deadening from the fence that will be in the way or any of the vegetation. We just assumed as if they were not fenced in for that purpose. And it was a quarter, at the worst case, it was a quarter of the sound that they would hear from the sound on the pavement, on their roofs, on their sidewalks. So there'd be no way to be able to hear the solar panels on the property, even in their backyards.
How close is the closest solar panel to the closest rear lot line of one of those residences on Great Meadow Drive?
Don't know, about 100 feet. Are you talking the home or the property line? It's probably about 70 feet from the nearest solar panel to the nearest property line. And 109 feet from the fence to the nearest residence.
So your testimony is 70 feet?
70 feet.
7-0. Thank you, Mr. Reed.
That's great. Then onto the electromagnetic waves. Okay, I'm sorry, 79 feet. I correct my testimony. 79 feet panel to the property line.
The closest solar panel to the nearest rear property line on Great Meadow is 79 feet?
That's 79 feet to the home. We have at least 50 feet from the...
No, I'm talking about from the rear lot line.
Right.
How far back from the rear lot line of the closest house on Great Meadow is the nearest?
It's 79 feet.
How many?
It is 79 feet.
79 feet?
Yes.
If I may add,
Sure.
one of the other things that was submitted to support this application to your board is a aerial photograph that has all the setbacks from the 3 homes that are closest, that shows the setbacks to the property line, setbacks to the fences, and the setbacks to the interior portions of the project.
Thank you, Mr. Shepherd.
With respect to electromagnetic waves, I think there's a misconception that the electromagnetic waves from the solar panels are different from electromagnetic waves from other devices, and that is absolutely false. They're basically, electromagnetic wave is an electromagnetic wave. And if somebody in their home watches TV, they're subjected to electromagnetic waves. If they use an electric mixer, a vacuum cleaner, a telephone, a cell phone, a computer, they're subjected to electromagnetic waves. And what we've done is given you calculations of what the electromagnetic waves are. And at the property line, the highest amount that could be at the nearest property line is 0.06 milligauss. That is comparable to all of the household devices that people are subjected to. So if somebody is watching TV in their homes, using a vacuum cleaner, talking on the phone, standing at the computer, they're subjecting themselves to considerably more electromagnetic waves than they're going to get from this. Even if they're walking in their backyard, there are electromagnetic waves coming from the earth. So there's not a meter accurate enough standing at the property line to measure an increase in electromagnetic waves from these panels. There's absolutely no question, and we obviously gave you the reports and the references for that there's not going to be any impact from this field unless somebody is basically living without electricity. If they're not using any electrical device and not walking down the street by power lines, then they may have less electromagnetic waves than this is putting out. But anybody who's using any kind of electricity is definitely orders of magnitude higher.
Is this calculation,
Speak up, Mr.
is this calculation done through one panel or 4,200 panels?
It's actually the inverters and the transformers. The panels give off very little. It's transformers. The highest ones are things that have coils, not a straight linear line. A vacuum, an electric drill has a huge amount of electromagnetic waves because you get a spinning motor, unshielded motor. A vacuum cleaner is very high because, again, it's got a motor. And devices that are just linear have less of that. And again, it varies by distance threefold, so that if you're 10 feet away, you're 1,000 times less than if you're 1 foot away. So the great distance that these inverters are from the property lines is what makes the difference. You take the level at that level, 300 feet times 300 feet times 300 feet is what you divide that by. And that's what makes it so low at the property line.
Mr. Riom, is it true that most of the electromagnetic waves are going to be generated in or around the inverter?
Yes, in the transformer.
And your testimony is that inverter is located 300 feet away from the nearest residential rear lot line?
Yes.
Continue.
The amount of power frequency EMF from the power inverter associated with the array is less than 0.4% of ICNRP's exposure threshold at a distance of 10 feet. At the distance of all surrounding homes, the power frequency EMF from the solar array will be less than 0.1% or undistinguishable from background EMF. All of this data is data that we submitted with the background, with the backup. That's all I have to say.
Thank you, Mr. Riom. Mr. Shepherd.
Thank you, Mr. Chairman. I guess what I think is important here is that this board tried to sift through the testimony to reach actual facts, much as a court reviews actual evidence. And I would suggest to you that, that the emotional pleas and unsubstantiated claims be set aside, that unfounded fears have no place in your review. You've heard a lot of factual misstatements. I do not intend to go through them all. But what I would like to do is just mention to you that it would be nice if you folks, and I know you will, take the time to actually look at the facts and what you have to support the various claims. In this particular project, you have so much information to support the claims of the applicant on this project, not just the prior decisions in other bodies of this municipality, but you have actual facts from outside third-party experts. You have facts from licensed professional engineer, and you have deep, thorough research on impacts from electromagnetic waves, from potential noise issues, from property value issues. And if you look at those facts, I think that the decision will be much easier for you. I'm happy that you have agreed that the applicable standard of review here is the bylaw that was in existence at the time that the filing was made. I know that there's been some comments that that may not be required, but I don't think that that anybody could make that contention in good faith. I think it's probably just a misunderstanding on the part of the people who are suggesting that you look at this in connection with the bylaw. Although I do appreciate the chair's notable reference to the fact that even with the new solar bylaw that was passed in town, this type of project could go in this type of residential agricultural district following appropriate permitting. It's also important here to note that the applicant had requested the building inspector to come in to support his determination, but we have a conspicuous absence of the building commissioner. Now I am aware that he is no longer employed by the town, but he still has no, to the best of my knowledge, no document to support the revocation of his previously granted building permit. And I think that it's unfortunate that we are in a situation where the permit was revoked, but there's no information in the record to support that revocation. And I'd just like to close with a couple of reminders here. The Zoning Act, Chapter 40A, Section 9B, indicates that solar systems may be exempted from setback, building height, and roof and lot coverages. Massachusetts has long supported and recognized the value of access to light. Chapter 40A, Section 3. We've gone over it, but again, no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building of structures that facilitate the collection of solar energy, exactly what this project is, except where necessary to protect public health, safety, or welfare. I think we've delivered to you sufficient information to eliminate health and safety questions in their entirety. The only non-fact-driven category here, and I don't mean that it's entirely non-fact-driven, but the only one that's really subject to an opinion, it would seem to me, is how one values welfare. And we have supported this application with an appraisal that was specific to this neighborhood. You will notice that it includes direct interviews with brokers who've sold the homes in this neighborhood. and their comments and their experiences in the sales of these homes. There's been much made of some deal that supposedly fell through, but there's no house that the house that applied to was sold, and somebody is living there today with full knowledge that this project was going forward at the time that they purchased it. Solar energy collection really does, as Massachusetts recognized as early as 1975 in the Mass Acts, Chapter 808, conserve natural resources, prevent pollution of the environment. We've heard a lot of people say that they are supportive of this type of project, which is great, and I think that their only problem is that they don't want it in their own backyard. I'll leave you with a couple of comments about equivalents that are also part of the record we have delivered to you. This project is the equivalent of removing permanently 200 cars from the road. This project is the equivalent of planting 450 acres of trees. We're talking about 50 million pounds of CO2 that won't go into the environment as a result of this project. And by the way, this is only a 1 megawatt project, not a 3 megawatt project, as was indicated by one person. Essentially, it's 75,000 barrels of oil will not be burned if this project gets approved. Thank you.
I have a few questions based on the evidence that we have received this evening that we have been trying to go through as rapidly as possible. These are large packages. And then I'd like to inquire of the rest of the board if they have any questions and allow them an opportunity to speak their mind and make inquiry. First of all, though, I owe you, Mr. Johnson, an apology because I called you Mr. Shepherd, and I'm sure this has to do with the lights. I think all of our brains are getting a little soft up here. It must be 100 degrees, honestly.
You are in good company, Mr. Chairman. I have all last names, and it's more commonly Mr. Shepherd than Mr. Johnson, I must tell you.
Well, I hope you took no offense.
I did not.
I did want to inquire, for the record, who do you represent?
I represent the project proponent and the property owner, Rocky Meadow Development and Borrego Power.
So your clients are both Rocky Meadow and Borrego?
Yes.
Thank you. One area that we have not discussed, or at least I don't remember discussing, is what happens when there's loss of tree canopy cover. We know that when there is loss of tree canopy cover over an area, it causes a heat island effect. And there are studies, some of which I've located, that indicate that after trees are removed from an area, that area in which the removal has occurred, there's an increase in temperature. Now, I want to draw your attention particularly to a study that occurred after one of those tornadoes hit out in the western part of the state in the Springfield area a few years ago. There was a study after those trees were leveled in a particular area, and that study was able to determine that there was a heat island effect that was caused, and that the air temperature in that area went up in the area or in the range of about 4 degrees. Now, that may not sound like a lot, but I would be interested in hearing from either one of you or both of you about whether you believe that now this large area has been removed of trees, if it's going to cause an increase in air temperature, And of course, we've got the solar panels there too, so there's going to be some heat generated by them. So can either one of you or both of you speak to that?
Maybe I can take a quick shot first, and then Mr. Reum can follow up.
Go ahead.
It's an interesting question you ask, because we have, we're both working on a project in another town where the concern is in fact the exact reverse, which is to say that with a large open area, which we already have out here, and which is going to remain an open area at this point, putting solar panels in actually reduces the heat by absorbing some of that energy. And really what this comes down to is this whole idea of a heat sink or an increase in heat has a lot to do with wind patterns and what total ground cover in an area is. So if you have a large swath of area that is taken out, that's one thing. But this is really just a few acres. There are actually some significant benefits that come from a project like this by way of animal habitat. Believe it or not, there are specific types of critters that actually prefer the type of habitat that will be created by this project. And it's a type of habitat that is diminishing in southeastern Mass. And so there's some real benefits to having it maintained as open space, because it allows, for example, enough cover for small animals to think they're safe, but really not enough cover to keep them away from the owls and the hawks and the other raptors, nor some of the other critters that live in these areas that, with heavy tree canopies, they don't have any access to the or way to hunt.
Other members of the board, please.
See if I can think clearly here. It's a little warm up here. First, I'd like to thank both the applicant and all the abutters and the people who spoke for providing us with the information that we did ask for. I can hardly see you out there. But who provided the information that we asked for. I know it was onerous on some to kind of dig it up again, but I do appreciate it, and I trust you. It's probably going on vacation with me next week, and we will go through it. Right now, I don't have any questions, I think, for myself. I really don't have any questions right now.
Mr. Collins.
I agree. At this time, I really have no questions. I want to read through all the material that we got to this evening.
Mr. Mueller.
Has the petitioner had any other projects cited in a residential area with this type of setback?
Yes, they have. A number of them. And as I pointed out, there's actually one right here in town. It was a different developer, of course, but it's right down there on Main Street next to your elementary school.
Done. Ms. Miller.
I'm all set.
I have a question now that it's bounced back to me.
Oh, thank you.
Phil, you're not a voting member of the board.
I know, but I can still ask a question.
Yes, you can.
My biggest issue, well, it's actually more just a clarification point, is regarding when the building inspector revoked the building permit. What was the reason given?
I'm not clear on what the reason was myself, so I'm probably not a great person to answer that question. I really didn't understand what the revocation was other than a political act.
Because he has to hand a piece of paper saying cease and desist, and there has to be a reason for it, correct? What's the reason given, please?
Based on the legal opinion that was given by Mr. Carver.
Okay. So it's not in revoking the building permit for failure to obtain a special permit? Because that's what was listed from council over here. Yeah, that's fine, please.
Yeah, it's part of your record already anyway. I'm sorry I don't have it at my fingertips.
Okay. That's why it's a point of clarification, only because I'm picking up two different reads from two different places. Okay. Are these your only copies?
That's fine.
Okay.
Steve, we didn't hear what he said. Could you just Were you just
Yeah, my
defining it?
apologies. Yeah, my question was what the reason was given for the revocation of the building permit to begin with, because when the cease and desist order is issued, it has to be a reason given. And in the document supplied by, and I'm sorry, because there's a whole lot of paper, I think it's Attorney Schwartz, it's listed that the revocation of the building permit for failure to obtain a special permit, but to my knowledge, without the solar bylaw in place, it wasn't required to have a special permit.
That's correct. There was not a special permit required.
But then listed here, right, the actual reason is, let's see, sorry, give me a second.
It's a letter underneath, Steve.
Oh, it's in this letter?
It was just here.
Okay. So in this case, right, the reason given is he has determined that the project does not comply with the use and dimensional requirements of the current provisions of the zoning bylaws of the town of Carver. So I guess in that respect, and based on this information, that's my major sticking point right now, is just in that area, Mr. Chairman.
Thank you.
You need those, and you also need... Oh, wait, thank you.
This was my copy. I have one other question. Famous last words. I had asked you folks to measure back 200 feet from the closest rear lot line to the residences on Great Meadow, and you folks kindly did that for us.
Yes, I believe we
And
provided a
I
plan.
had a follow-up question that I had asked, and you're nodding like you know where I'm going to go with this. And the follow-up question was, what percentage of the project would be affected if it were pushed back 200 feet from the closest residential rear lot line?
I can answer that question. Jared Connell from Borrego Solar. The plan that we provided to you guys that shows that 200-foot setback from the lot lines results in a system of 589 kilowatts. The system being 1 megawatt, that's about 40% of the system that's affected.
Thank you for that. Mr. Johnson, any final comments?
Only to thank the members of the Zoning Board of Appeals of Carver for your deliberations and good work. I know that the pay is not great, but the town does very much appreciate your service, as do my clients. Thank you.
And thank you for your graciousness. Unless there is the feeling amongst a member or members of the public that there is a compelling need to respond to what you've just heard, I would like to move on to the next stage of this proceeding. So is there something that somebody wants to say that we have not already heard, or a point of correction, factual correction that you believe needs to be made for the record? We're prepared to hear you. And again, I want these comments very circumscribed, okay? Like a minute, and then back to your chair. Yes, ma'am.
Hi, again, Mary Burbine at 16 Great Meadow. I just want to make it clear, I feel as though I've been singled out to the fact that I agreed to this project, moving into this home. That is so far from the truth. I want everybody to know that. Moving into this home, I was not told what was happening behind the house. I was told that there was something maybe going to happen, was not sure what was going to happen. So at the time, I was 6 months pregnant, I was on my way out of work, and we purchased a home at obviously a significant lower cost than what they wanted. So it worked out for my favor at the time. I was not aware of what was going on. Now that I am, it's definitely not anything that I am for, and I just, me or my husband, just so that everybody is clear and everybody on the board knows that I am not for this whatsoever.
Thank you.
Okay, thank you.
Sorry, ma'am, could you state your name again?
Yes. It's Mary Burbine at 16 Great Meadow Drive.
Thank you.
Okay. Again, the need to make a compelling correction, at least in your opinion? Yes, ma'am. I don't want this going on for another half an hour or hour here, okay? Okay.
Kathy O'Brien, 4 Great Meadow Drive. They were talking about the magnetic waves and that would only give a certain amount of power off, like a microwave or a vacuum cleaner. I will not be running my vacuum cleaner or microwave 24 hours constantly. So if they're comparing that to a microwave or a vacuum cleaner, I don't vacuum my house 24 hours. You can't shut these panels off. I can shut my vacuum cleaner off. That's all I wanted to say.
I see 2 more hands only, and those are the folks I will recognize, and then we'll call this stage of the proceedings over. Gentleman on the left.
Again, Edward Todd, 3 Great Meadow. I just want to state, as a resident, that I live there. Not one of these people who are for the project live next to this, or are going to live next to this. So all of the people that have come up to you stating that they're worried about their welfare of their house or their children or any of that are going to be, whether you say yes or no to this, we're still going to live there. These people, it's all about the bottom dollar. They're not living there. They're not going to be affected by if there's anything of health or wellness. They can just leave, and I can't leave. You know, I can't just move out and go find another place to live. I'm stuck where I am, along with my neighbors. We were here first, you know. I don't know what else to say. I mean, I'm not good at speaking.
Well, you've said it, and we appreciate it.
Basically, that's what I'm saying. We're there. They're not living there. They're not going to see it.
We get it.
Thank you.
Thank you, Edward. And finally,
Just 3 quick points. James O'Brien, 4 Great Meadow Drive. Number one, the proponents had mentioned the nearest panel being 75 feet.
79.
79 feet. You've been out to the site. You've seen the site. We were just out there earlier today. There's absolutely no way that that closest panel is 79 feet from his property line. That's an inaccurate statement. It's also an inaccurate statement that the peer review was an independent review, considering that Beaufort and Glenn Berkowitz had proposals to try and get solar projects into Carver, particularly the Route 44 project, which leads to believe that there was a bias towards, it wasn't a completely independent point of view. At that time, there were attempts by Beaufort to buy solar projects into Carver. That's not an independent point of view. And lastly, in that, what I had given you there with the building permit, they were talking about the building inspector. When you look at the building permit for this town, on that it says proposed use. And on the building permit here, there's absolutely nothing checked on that. It says single-family, non-residential, multifamily. There's nothing checked. And when it says, is the project near stream, river, pond, wetlands, bog, not applicable, nothing is checked there either. So this is an incomplete building permit from the beginning.
Okay.
It never should have got that far. Thank you.
Thank you. Yes, you may. Come down to the microphone, would you please? I don't think we've heard from you yet, have we? And again, very brief, please.
My name is Barry McNeil from Rocky Meadow Development Corp., and I'm the applicant.
Yes.
And I'd just like to say to the people and the board that I have 13,000 solar panels in my backyard that are about 70 feet from the back door of my house. I have a 9-year-old son and a 13-year-old daughter, which play in the yard as well as I do. It emits no noise whatsoever. I did my research on whether I thought it would be harmful to my children or not before I moved ahead and put the project in, and I never would have put my own family's health, safety, and welfare at stake if that was the case. So I'd just like to add that. Thank you.
And thank you for that contribution. Mr. Johnson, you've got the final word if you care to have it, and if you don't care to have it, we would be grateful.
Thank you.
Okay. Let me make some remarks here. about this matter and the application of law as it applies to this particular project. Before I do, I, like my colleagues, want to thank both sides for a thorough and professional presentation. This is obviously a deeply emotional issue for some of you. And from where I sit anyway, I have been impressed by your eloquence and your quiet passion and concerns. And likewise, the petitioners have presented, I feel anyway, a strong case for their side. So this has been helpful, at least for me, and I'm sure the rest of the members of this board, to hear from all of you. And as I've said more than once already, and it's worth saying again, we do hear all of you, both sides, and we are clearly weighing the evidence and struggling to find the right way to apply the facts to the law in this case. As Mr. Johnson has said, however, we can't make this decision based on passion. We must make a fact-based decision. But having said that, the Supreme Judicial Court in Massachusetts, our state Supreme Court, has explained that the concept of public welfare, which is one of those words in that phrase in Chapter 48, Section 3 that we've all heard ad nauseum now, is broad and inclusive. And the values that public welfare represent are spiritual, as well as physical, aesthetic, as well as monetary. The Supreme Judicial Court has found that it is within the power of the legislature to determine that the community should be beautiful, as well as healthy, spacious as well as clean, well-balanced as well as carefully patrolled. Now, in making the determination that this board will eventually have to make, we are granted considerable discretion based upon the cases that interpret what public welfare means. Of course, health and safety are part of this as well, but I want to focus in on welfare for a minute, public welfare. And our decision with regard to whether this project is consonant with public welfare is going to depend upon the facts. Again, I keep talking about the facts. We have been given a voluminous amount of material tonight, and I'm sure that I'm not the only one up here who feels that they're going to need time to sift through all of this paper. I know that, for one, I'm not prepared to reach a decision on the merits this evening for that reason. We will need to circle back in August before we're prepared, thoroughly prepared, to make a decision. I apologize to all of you who came here tonight thinking that the meeting tonight was going to be the penultimate meeting and that we would eventually come to a decision. We want to be careful. We want to be thorough. I can say, however, that based upon the comments that I've heard from both sides and based on the evidence that I have reviewed to date, as well as my reading of the cases and how our state Supreme Court interprets the words public welfare, that this project does not satisfy me yet that it is consonant with the interests of public welfare. I am concerned with regard to the issues of property value diminution and the loss of aesthetics in this neighborhood, both of which are proper concerns, again, based upon case law. I hasten to add that my concerns with regard to these issues are not necessarily shared by the other board members. I'm speaking for myself only at this point. And I would like to suggest some things that I've thought about as I've listened to everybody that would be helpful in addressing some of my concerns with regard to public welfare. First, it appears to me anyway, after going on this site walk, that the project is located very close to the rear lot line of those homes along Great Meadow. And I know that if the petitioner had come to either the planning board, or I suspect that the petitioner had come to the planning board or had come to us and said, look, this is kind of close, and in view of the opposition in the neighborhood, because we want to be good neighbors ourselves, we're going to agree to voluntarily push this thing back 200 feet from the closest rear lot line of those homes along Great Meadow. That would have been helpful for me to hear. I'm not hearing that. It's awfully close as it's presently situated. Second, I'm not hearing anything offered by the petitioners at this point concerning how this project is going to benefit the neighborhood. Based on what I have seen so far in the evidence, and acknowledging that there is now a report from an appraiser in the file, I'm still not convinced that there won't be a diminution in property value as a result of the siting of this project so close to these homes, most especially on Great Meadow. So in order to satisfy public welfare, I wonder if some benefit can be formulated whereby this neighborhood can be benefited financially due to the diminution, or what I tend to believe at this point is the diminution of their property values. Is there some way to mitigate that? And I suggest that there might be. And I'm thinking outside the box here a little bit. I wonder if the petitioners have thought, and this is a rhetorical question, I wonder if the petitioners have thought about the possibility of providing free power to the abutters who are most directly affected and whose property values are most directly affected by this project. This would mitigate any negative influence on their property values, it seems to me. A couple of other thoughts. I don't know whose idea it was to place a white fence and security gate around this project. I think that's going to be very obtrusive, and if the petitioner could perhaps think about changing color to a brown or greenish color, that might make the project less obtrusive and more consonant with public welfare. The driveway access, or I don't know if you want to call it a driveway, but the access off Great Meadow to the security gate, At this point, I'm not sure that there's any plan to pave that. I think it's in the plan for it to be a dirt road in. And I'm not saying the dirt road be on the security gate, but the dirt road off the public way just to the security gate, to cut down on dust and debris. I'm thinking, gee, why don't they think about paving that? That might be helpful also and might improve aesthetics and have a more positive influence on public welfare. These are just some of my thoughts as an individual board member. And I want to ask if any members of the board would like to weigh in with their thoughts or comments or criticisms of what I might just have said. Anybody to my left? Anybody to my right?
That's a lot to digest on the scope of this project, because, as you said, other than maybe the color of the fence or something like that during the sidewalk, mitigating damages basically to this impacted neighborhood hasn't really been brought up. And I don't know if this was part of the planning board discussions. I mean, I know that there's power exchanges, either giving something back to the town or giving something back to impacted neighborhoods. They do exist, but was anything like that ever discussed in the planning board? Anybody? Can't see out there. No. Thank you. Oh, that was like town meeting. I mean, it's something definitely, as Chairman Gray says, a little bit outside the box. I don't know if this is something that they're prepared to think about, or, I mean, I would have to think about it myself right now. But.
Anyone else? What I was going to suggest at this stage, and it's a suggestion only, and believe me, ladies and gentlemen, I'm not tipping my hand here one way or the other. I'm just kind of talking about what my general thoughts are at this point after having listened to now over 6 hours of testimony. I'm thinking that perhaps a meeting can be scheduled with the petitioners and their representatives, a member of the zoning board, and perhaps the Director of Planning and Development in the town of Carver, so that these issues can be discussed, weighed, and so that the petitioner, when we come back, can decide or report to us whether it wishes to make any tweaks along these lines or any other lines. It would get me, anyway, to a better comfort level than where I'm at right now. So I would make a motion that we designate Vice Chair Sharon Clark to be the representative of the zoning board on this, at this meeting, that we would sincerely ask the petitioners to participate in. You can choose not to participate. You can hold our feet to the fire and say, okay, make the decision up or down right now. But I think it would be helpful. You have expressed the desire to be good neighbors here. I think that that's a genuine wish on your part. I don't question that. But it is clear that the interests here of your client and many of the neighbors are inimical and opposed. So let's see if we can have some discussions, think about some of these suggestions, think about the comments and testimony that you've heard over the last couple of meetings, and we can come back in August. You can report on what you feel you might want to do, if anything, with regard to this project. We can take that up at that time, and I would imagine that barring something unusual or complex, we will likely go to vote. Madam Clerk, when is the next meeting?
August 8th.
Everybody good on August 8th? I see Mr. Collins shaking his head, and we need Mr. Collins.
That's my daughter's first birthday.
Oh, well, we don't want to, we don't want to keep Daddy away from daughter's birthday number 1. So is there another day that week that works for you?
Anything.
How about the 7th? Mr. Corbett. Mr. Johnson?
Yes.
7th is good for you?
I'll make it good.
And Mr. Reum? And I'm sorry I didn't get your name, but you good with August 7th? Okay. So I'm going to make a motion that we designate Vice Chair Sharon Clark to schedule a meeting through the Office of Development and Planning in the town of Carver, that both she and Mr. Hunter can attend with Mr. Johnson and representatives from the petitioner who might wish to attend, so that issues concerning public welfare and the concerns that you've heard from the neighborhood and some of the issues that I've talked about tonight over the last 5-10 minutes or so can be thoroughly vetted. Then we come back, we hear from you, and we'll make a decision.
Thank you.
Is there a second to putting me on this?
Yes. Is there a second to my motion to designate Vice Chair Clark to be our representative during this meeting?
Second. Say aye.
Ms. Mello seconds. Is there discussion? Ms. Clark, you don't want to do it?
Can I say anything?
Yes, you can.
No, I'm good.
You good?
Yeah, I'm good. It'll get me
No,
off the stairs.
it's not a public meeting because we won't be in public session. There'll be only one board member present. And not to fear that anything is going to be said behind closed doors that you folks won't know about, because we're going to report the next time we come into public session in August.
I think that's what they're talking about.
Can I just
August
clarify?
7th.
You're saying
August 7th.
August 7th is the next meeting of the full board?
Right. full
And
board.
between now and then, you're suggesting this type of get-together?
Yes.
Thank you.
Yes. Thank you for clarifying that. Is everybody clear on that? No. Yes. Yep. That will not be a public meeting. We're not making any deals, ma'am. No deals. No. Well, I'm not quite sure how to respond to that, other than to say, and you've heard me say this now on more than one occasion, we are not influenced in any way, shape, manner, or form about what's happened before concerning this case. I understand that you've got concerns about certain personalities. I don't, because I don't come with any of that baggage to this case. I assure you that whatever is discussed at this meeting is going to be reported by Ms. Clark, and also, I'm sure Mr. Johnson will weigh in. I think it's important that the issues that have been raised, and there have been many, be considered and discussed by the petitioner and by the Office of Development and Planning, and one of us will be present, eyes and ears of this board. So we make the promise to you that we will report thoroughly concerning what happens at this meeting. Now, No decisions are going to be made at this meeting, and I think Mr. Hunter's presence is really only going to be necessary, most particularly with regard to the issue of whether the petitioner wants to consider energy credits for those folks in the neighborhood who are going to be most directly affected by this project, if that's an issue that we determine is important in the furtherance of public welfare and mitigating the negative effects on property valuation. Okay? You can suggest it, but I'll inquire of the other board members whether they have any thoughts about this.
Given the taste that the abutters have at the moment, I'm not opposed to one member attending.
Yeah, if they want to designate one.
I'm not opposed to one member.
I would say one member is.
Just one member, though.
Okay.
That way everybody's represented.
Right, and that hopefully will get you over any concerns about backroom deals or strong personalities who are directing the discussion. Yeah, but I want to note one point of caution, and that is, although most of you seem to be in accordance with regard to your opposition to this project, some of you are coming at it from different angles and different directions. Some of you have got more concerns about health, others more concerned about welfare. So be careful about who it is that you decide to designate as the person that you want to be part of this meeting. There are a lot of you out there, and it's hard to pick just one person to speak for everybody. Okay? You're welcome.
Mr. Chairman, just one question. Who's the point of contact to assemble the meeting? So when, I'm assuming that the abutters are going to need to discuss amongst themselves, who are they going to talk to make sure that they're included?
Well, we have our intrepid clerk, Ms. Carlino, who can be contacted.
Sure.
Right? And she will help coordinate this meeting with everybody. So whoever it is that the neighborhood wishes to designate as its representative at this meeting, please contact Ms. Carlino. And if you are able to make this decision tonight, you can see her before we suspend and give her your contact information. Okay? So there was a motion and then a second, I think, by Ms. Mello. Is that correct?
Yes.
Is there any further discussion?
But you're going to amend that motion by adding.
Yes, we're going to amend that motion, thank you, by adding a neighborhood representative to this meeting. Is there any further discussion with regard to this motion?
I make a motion that we amend the original motion to add a member of the public to that meeting.
Okay. All right. So I guess we need a second to the motion to amend. Any discussion on the motion to amend? Hearing none, all in favor?
Aye.
Okay. So now we're back to the original motion, which I made, seconded by Ms. Mello, I believe. We're going to have a meeting amongst the developer and its representatives, a neighborhood representative, the Director of Planning and Development, and Ms. Clark on behalf of the Zoning Board to discuss the concerns and possible tweaks to this project that might get some of us over the hump. Any further discussions on this? Hearing none, all in favor? So again, the contact person will be Ms. Carlino to get this scheduled. We'll come back the beginning of August 7th, is that right?
Yes.
And we'll be at 7 o'clock. Watch the publication, people. I don't know whether we're going to be here in this venue, and I hope not, because I can feel now the hair on the top of my head, which is already kind of thin, is burned down to scalp level. I'm hoping that we might all be able to get into the selectmen's quarters, but if not, then we will, if we get the feeling that there will be a large turnout, we will return here under the hot lights once more. Is there anything else that we need to go over?
I'd
Good.
like to know when we're going to get copies of...
Ms. Clark, I think I heard you say...
All that.
Ms. Clark,
Monday.
I'll try to do that.
I thought I heard you say you're on vacation coming up.
Just 2 days next week.
Oh.
Like, I miss all this?
All right. So, do I hear a motion to adjourn?
I will make the motion to adjourn.
I have a second. Yes.
We need to continue the hearing.
Oh, yes, we've got to continue the hearing. Okay,
Chair,
so,
I'll make a motion to continue this hearing until August 7th.
yep.
Second.
Any discussion? Hearing none, all in favor?
Aye.
Okay. Motion to adjourn.
So
I'll make
moved.
the motion to adjourn.
Second? All in favor?
Aye.
Thank you, ladies and gentlemen. Thank you.